Good afternoon, everyone. Thank you so much for signing up for this webinar today. My name is Stephanie Brown. I'm a solicitor here at Michael Lynch Family Lawyers, and today we're going to be talking through relocation matters, which is something that does come up quite often in relation to parenting arrangements when parties are separated. And we'll talk a little bit about the different options and everyone's, I guess, topic that we can't get away from at the moment, the impact that COVID-19 has had on some of those matters as well. So that's what we'll be doing today. This is just a quick overview of the things we'll be going through this afternoon. So we'll talk about when relocations matters may arise in a family law matter, and then there'll be a little bit about the parenting arrangements under the legislation and how the court determines parenting arrangements generally, and then talking about how that impacts relocation matters, particularly talking through the court process. And then, as I said, we will talk about COVID-19 and how that has had an impact on some of these decisions that the court's making. There are no specific legislative provisions that deal with relocation matters. So it's the case that the court has to go through the usual parenting pathway and the usual sections that they go through when they're determining a parenting matter, and then apply that to the specific facts of the case and look at that in the context of one parent trying to relocate with children. So it's not necessarily that we need to look at different sections of the legislation. It's the same sections, and I'll take you through those sections and the relevant provisions, but it's applying to a different set of facts to normal. In relocation matters, each matter will differ quite a lot, and to be honest, it's the same in any parenting matter. Obviously, each family is different. All families are different. Children are different. We've got different facts. So the court does need to look at the particular circumstances in each case. With relocation matters, that does make it difficult for solicitors to give a clear answer because it really does depend on the particular case and the parties that are involved in the proceedings. This is just a few statistics that I found on relocation matters from an Australian Institute of Family Studies in 2011. So just some interesting facts I thought from looking at it. So usually it's the mother that wants to relocate. That was the case in 88% of the matters that were looked at. Most of the matters could be described as high conflict, and I would say that that probably is the case for most matters that end up going all the way through to a final hearing in the courts anyway. Generally, it is that high conflict kind of relationship that requires significant court intervention or significant legal intervention. 57% of the applications were approved, so that means that the children were allowed to relocate with the parent that was asking for the relocation. Parents relocating back to their birthplace was approved 75% of the time, and we'll have a little bit of a chat about why that might be and how those factors may have influenced the court to determine that. And parents relocating to be with a new partner were approved 54% of the time. So that's just a few stats to give you I guess an idea of the difficulty that does come up with relocation matters. That stat there, 57% of applications were approved. Generally, when we look at the cases, it's about 50-50. So it is a really hard thing to give a clear answer on unless we sit down and really look through all the facts. So there's a few different issues that come up which are quite unique to relocation matters, which may be different to the other general parenting day-to-day stuff that family lawyers see. So obviously it's a big conflict for the court between the best interests of the children, and that's really what a court needs to determine when they're looking at a parenting matter, and that conflict of the interest and the right of a parent to be able to move on and live their life, and the freedom of movement for a parent. So what we often hear people say is, well, how can she stop me from moving? You know, I'm just trying to get on with my life, etc. But I guess it really comes down to not necessarily that parent moving, but whether the children moving is going to have an impact on them. And that's the real balance that the court needs to consider. I've just put a quote in there from a case that kind of addresses that. One of the objects of modern family law statutes is to enable parties to a broken relationship to start a new life for themselves, to control their own future destinies, and where desired, to form new relationships free from unnecessary interference from a former spouse or partner or from a court. So that really summarizes that need for, you know, adults to be able to make that freedom of movement decision. However, sometimes that decision does conflict with the best interest of the children and them having that relationship with the other parent. So it is a real balancing act. The other, I guess, unique thing that comes up in relocation matters is that it's a really hard thing to try and agree between two people, because there is really no middle ground. It's not the same as if people are having a discussion about whether a child should spend 5 nights at dad's or 7 nights at dad's in a fortnight. That's something that often comes up. Family lawyers have those discussions all the time. There are different ways we can approach that, and both parties may be able to make concessions and meet in the middle. When you're looking at a relocation matter, it's really an all or nothing. So if one person wants to move to New Zealand, say, and the other person's in Australia, there's no middle ground. They can't move halfway. Really, it's the negotiations around what does the time look like if that person does move with the children, but there's not that kind of middle ground that we would usually have when we're talking about a parenting matter generally. So unless one party concedes, or we can get some ground back in terms of time with the other parent and maybe making some other concessions. Sometimes it's financial concessions, so agreeing to pay for flights back and forth and things like that. There is really no middle ground. It is quite positional. So often relocation matters do have to go through to a trial to get that decision made. So there's 2 ways usually that a relocation matter will come to the court's attention. And I'll just foreshadow this by saying, if there are 2 parties who are separated and one of those parties is wanting to relocate with children, and the other parent agrees to that and they come to their own decision about that, obviously that is fine. That's preferred, that people can reach agreement. That could be documented, or it could be an informal agreement. That is, parties can do that outside of the court system. I guess what we're really talking about today is more when parties haven't been able to come to that agreement and they then need to defer to the court to make that decision. So that would usually happen in one of 2 ways. The first way is that the parent who is wanting to move with the children files an initiating application with the court, requesting that the court make orders essentially that the children be allowed to move, and then those orders would also include time for the children to spend with the other parent and holiday time and things that we would usually see in a parenting order. The second way that it can come to the court's attention, and this is not uncommon, unfortunately, is if a parent actually follows through with the relocation without the consent of the other parent, and then the parent who's been left behind files what's called a recovery application in the court. So that recovery application means that the parent is filing in the court, asking the court to order that the children be returned to where they were living previously, and then the court makes orders after that. And usually what happens is, if the recovery order is issued and the children move back, that's an interim decision. That will still then need to go through the court process to determine on a final basis whether the relocation should or shouldn't happen. So that's the 2 ways that they usually come to the court. Obviously, if parents are negotiating about a relocation, then that can happen through your usual pathways. So whether it's direct discussions or mediation or having lawyers try and negotiate that. So that's kind of outside of that court process. Once parties are involved in the court process, then there's a few things. They can obviously agree at some point along that process as well, and the same kind of thing, they could go to a mediation or anything like that. And one of the things that the court will often do is get a family report done. which then determines and gives recommendations about the children's best interest, and that report could consider the relocation specifically. So as I said, really when we're looking at relocations, it's just a different, it's a parenting matter that we look at through the usual parenting provisions in the Act, but it just has a few of those more unique characteristics that we spoke about previously. So in relocation matters and in all parenting matters, we start from a presumption that it is in the child's best interest for separated parents to share responsibility for decision making about those long-term issues. So that's called equal shared parental responsibility. That's a concept that family lawyers often refer to, and I'm sure you've all heard that term used in relation to parenting arrangements. So equal shared parental responsibility relates to those long-term issues like religion, what school children attend, etc. But particularly for relocation matters, it talks about the decision of where a child is living, if that move will affect the child's time with a parent. So that then becomes an issue that's a long-term issue. Excuse me. So essentially what that means is one parent can't move the children's residence without the consent of the other parent if that will change the parenting arrangements that have been in place. Obviously, that is then dependent on what the parenting arrangements were previously. So often we have clients who say, okay, well, I'm living in, you know, somewhere at South Brisbane, can I move to the Gold Coast? There's no, I guess, defined kilometre radius that you can or can't move in. It really depends. Obviously, if the other parent was having time every second weekend from Friday to Monday, maybe that distance won't affect that time, in which case there's not necessarily any need to have the other parent's consent. That is very different to somewhere where you've got week on, week off, and someone's moving 2 hours away and there's going to have to be a school change. That might make that a very impracticable arrangement. So it really does depend on the particular circumstances, as I spoke about earlier, and I'll keep coming back to that. So assuming that presumption of equal shared parental responsibility applies, a relocation decision needs to be made with both parents consenting if it does impact the time. Obviously, there are certain circumstances where it's not appropriate for parents to have equal shared parental responsibility, and that's when we start looking at instances of family violence or abuse. Then that presumption may not apply, and in those cases, the court may decide that one parent needs to have sole parental responsibility for those decisions. That's a very different class of cases than what I'm talking about today, because the relocations that I'll be talking about today are more those ones where it is necessary to have consent, and that's why it's been brought to the court's attention. It's more common, obviously, to have equal shared parental responsibility, so that is more of the cases that we see. So those separate categories would require specific advice about those. So the other big principle that family lawyers talk about all the time, and I'm sure you've all heard, whether it's from clients or other seminars and things, is this best interest of the child, which is the paramount consideration for the court to look at. And that's the consideration that the court keeps needing to come back to. So there's not necessarily any presumption or weighting in favour of or against relocation. So the court doesn't start from a position of yes to a relocation or no to relocation. We just need to keep coming back to this principle of best interests of the child. And that principle applies to all parenting arrangements, whether we're talking about a relocation matter or not. So the court obviously usually has two proposals, one from each parent saying this is what I say is best for my child, and the other parent will have a different version of that, obviously. So the court looks at both of those through this lens of what's best for the child. And they don't necessarily have to only go with one of the two proposals that they have. they can come up with some kind of hybrid or some third option, and that's the whole point of the court being able to look at the best interests of the child, is that they may decide that there is some other proposal that is more appropriate for the child in that particular family situation. So the court looks at this best interest by looking at primary and secondary considerations, which are set out in the legislation, and I'll take you through those in a moment. And that's section 60cc. If anyone's particularly keen and wants to go have a look at the legislation, you'll find that in the Family Law Act, but I will take you through those as well. So going back to that equal shared parental responsibility that we spoke about, in 90% of cases that there will be a presumption that of equal shared parental responsibility, and the court must then consider whether it's in the child's best interest to spend equal time with each parent, and is that reasonably practicable. So just because, and this is something that is a bit of a misconception, and we hear this a lot from clients, just because there's equal parental responsibility does not mean that you automatically have equal time. So the parental responsibility is your decision-making power, your decision-making needing to consult with the other parent about those long-term issues. The time is obviously the day-to-day time and where the children are living. So two very different concepts, and often they get a little bit jumbled when we hear from clients that they've been reading about equal parental responsibility. So just important to make that distinction. The first thing the court needs to consider is equal time and if this is practical. So obviously when we're discussing a relocation matter, if the court grants the relocations, it's not going to be practical usually to do equal time, because obviously the relocation is creating some kind of distance that means that that's not going to be possible. So I guess that is a good indication of the fact that the court, that's the first thing the court needs to consider, and that does make a relocation matter a little bit different and a lot more complicated for the court to consider. The next step that the court looks at is, if that's not appropriate, not practicable, is it in the child's best interest to spend significant and substantial time, and is this practicable? So significant and substantial time, there's no clear definition. That doesn't necessarily mean it has to be 4 or 5 nights a fortnight and half school holidays. So that might mean that if parents are living some distance apart, it might mean that the non-primary parent is having a significant amount of time, like every school holidays, and then a few visits during the term, or long weekends and school holidays and extra time during the term. So that can be made up of very different things, and I'll talk a little bit about how the court looks at that in a second. Again, sometimes depending on the distance, if you're looking at an international relocation where someone's a significant distance away, then that may even not be practicable. That doesn't necessarily mean the court won't decide it's in the best interests of the children, but it just means the court needs to look at how they structure the time with the other parent to maintain that meaningful relationship. So if that's not practical, then the court just needs to look at, okay, what is going to work and what is satisfying that need for the child to have the relationship and what's in their best interest. And we'll look at those primary and additional considerations shortly. So obviously equal time is 50-50. Substantial and significant time is generally where we're looking at making sure parents are having weekend, holiday time, school days and non-school days. That may be a little bit different when we're looking at a relocation just because of that distance. So ordinarily, if parents were living within, driving distance of each other, significant and substantial time is maybe like your 5-9 split of a fortnight, so 5 nights with the non-primary parent. That's when they could do, they're doing school drop-offs and things like that. When you're looking at a relocation, it's probably more, visits during the term and school holiday time, and obviously, video calls and FaceTime calls and things like that. So obviously how far apart parents are living is a very relevant consideration. Very different if you're looking at from Brisbane to, say, Townsville, to if you're looking at, Brisbane to someone living in London with children. So it's a whole, and there's a whole range of different elements that come into that, including the financial capacity of the parents to support, you know, the travel and the time that the children have with the other parent. So communication is a really big thing that the court needs to look at as well from a practical perspective. If parents aren't able to communicate to resolve any difficulties that arise, and that's, you know, travel and airports and schools and things are going to be things that do arise when children are living, whether they're living close to both parents or apart from one of them. But I guess that communication issue is something that the court does often come back to, because it just shows it is going to be really important for the parent that has the children more of the time to be able to facilitate that relationship with the other parent if there is that significant physical distance. So that's a relevant factor as well. The impact of the arrangement on the child. So that can be, you know, things looking at how settled the child is at school, what's the new school look like, all those practical arrangements, to also looking at, obviously, how is it going to impact the child needing to move away from one of their parents. What's the bond like between the child and the other parent that won't be relocating? And when we're looking at that bond, I guess sometimes, you know, having a really strong bond between that parent and the child may actually mean that the relocation is more successful, because the child already has that connection. So it may not be that the child will be particularly negatively impacted if they don't see the other parent for a term. Whereas sometimes if they haven't had that really strong connection to their parent, then that may mean that it does have more of an impact on that relationship with the parent, and then any other relevant matter. So the court does have a broad discretion to look at basically any factor. And as I said, because each family situation, each child is so different, there are sometimes things that come up that aren't necessarily thought of before. So as I said, the primary considerations, so we've got the best interests of the child, and then the primary considerations kind of sit underneath that. So the two primary considerations for the court are the benefit to the child of having a meaningful relationship with both of that child's parents, and also obviously there's a need to protect the child from physical or psychological harm and family violence. So again, obviously there's always that exemption, and you know, family violence and domestic violence is something that does come up in family law matters quite regularly. The court just needs to look at whether the relationship with the child with one of their parents is going to be, you know, having that meaningful relationship, and whether that there is any need to protect the child. So that's the two considerations. Neither of them are weighted as greater than the other. They're obviously both relevant when the court's looking at parenting matters. And then the Section 60cc has all these additional considerations that the court looks at. So this is where we really start looking at the more specific circumstances that may arise in particular situations, and then obviously applying them to the context of the relocation that we're looking at particularly. So views expressed by the children, that can be a bit of a tricky one, and it's probably something you guys hear in your own practices. Often we hear parents say, okay, well, what age can my child choose where they live, or what age can my child pick which parent they want to live with? There is technically no age at which a child gets to elect. So often we hear 12 thrown around, 12 years of age. The court can make orders for children up until they are 18, but the views of older children are obviously given more weight because they're much more, they're a more mature view, they're a considered view. Younger children, you just can't take their view into account as much because they don't understand as well, obviously. So there's no particular age. It will depend on the maturity of the child and how, you know, what their views are and how those views have come about. If there's evidence, for example, that a child has been influenced by one parent, then those views may be given less weight. A very mature 10-year-old who's expressed clear views may be given more weight than a child who's 13 but doesn't have the the mental maturity of a younger child. So again, it's one of those things where there's no specific answer, but it's really important that people don't carry on with the misconception that there's an age that their child can pick, because we do often hear it, and I think that parents sometimes tell children that there's an age they get to pick, and it's just not the case. It really needs to be specifically discussed as one of these factors that the court looks at. So obviously the nature of the child's relationship with each of their parents and any other person such as grandparents or relatives. So often one of the reasons people give for wanting to relocate with children is because they are moving, one of the statistics earlier was moving back to their hometown. So moving back to have family support is often a really big thing. Obviously when parties separate, so previously there's been two parents living in the home, supporting the children, doing all the work with the children. Sometimes when there's been a separation and one parent's left with primary care of the kids but no longer has that other support, they might decide that they need to be back with other family support or friend support. The extent each parent has taken to participate in decision making and spend time with and communicate with the child, again, that comes down to, I guess, you know, what's the relationship like and how is it going to be impacted? The likely effect of a change in circumstances for the child, including separation from a parent or relative, practical difficulties of spending time and communicating with the other parent, and expense or difficulty of that time. So that's something I touched on previously. Often if parties are negotiating about a relocation, then some of the negotiation will come down to flights, or who's going to be responsible for driving. Is there a halfway point we can meet? So those kind of things do come up from a practical perspective. And sometimes that, I guess, is talked about in the context of child support payments as well. Parents' capacity to provide for the child's emotional and intellectual needs, maturity, sex, lifestyle and background of the child and the parents, that may be relevant. If there's Indigenous children, then that's a relevant factor as well in terms of keeping them connected to their culture. Any family violence, and if there's any family violence or domestic violence orders in place, the court does need to look at those as well. Whether an order should be made that would be least likely to lead to future proceedings. So essentially the court, they're incredibly overworked. It's a very busy court that we have, because there's unfortunately a lot of parents that need the court's assistance to make parenting matters. So the court tries to look at the arrangements that are least likely to lead to future disputes between the parents, because future disputes are potentially matters that end up back in court. So, and that's not necessarily from a court load perspective, that's also from the fact that parents should be able to know that a decision's been made and it's not going to get dragged up again, and that, you know, they can move on with their lives and they've got the kids sorted and everything. So that's where that element comes from. And then there's just this general overarching any other fact or circumstance that the court thinks is relevant. So what often comes up in relocation matters is there's a few different reasons that we most often see for why parents are relocating. So as I said, going back to family support is a very common one. Employment, so finding employment opportunities in another state or country. Repartnering is another big one that comes up quite often, or new partners having other employment opportunities. So the court again needs to weigh up how that impacts the children and what other factors we can look at. And obviously going back to hometowns, that's probably the major ones that we see when it comes back to the court. So that's, I guess, those other factors that the court would be looking at would fall under that. So that, I guess, is a little bit generally about relocation matters and generally about parenting matters and when they come up. So as I said before, it's about a 50-50 as to whether the relocation is granted or not. So that's that's, I guess, pre-COVID, that's how it all worked. Obviously, coronavirus has had an impact, particularly on relocation matters that are currently kind of going through the court. It's obviously had an impact. I mean, it's had an impact on everything, but it's had an impact on previous arrangements if people were living interstate or in different countries, you know, and there's different states have different border closures, quarantine measures, different testing requirements. When COVID first hit, there was a lot of people withholding children from the other parent because they were unsure what was happening with quarantine and everything. So we've kind of worked through that initial stage of unknown, and we're now in this new stage where I guess still very unknown in terms of when is the travel going to be allowed, when are the borders going to open, but I guess we're working in a little bit more of a stable environment in terms of a lot of those day-to-day parenting matters that were initially impacted. So yeah, obviously, particularly relocation matters, if parents are hoping to move overseas, say to New Zealand, then that may be significantly impacted, not only from their own perspective in terms of the practicalities of getting over there and quarantining when they get there, but once they are there, obviously there's a big question mark on when another parent may be able to visit and spend time with the children, or whether the children would be able to go back and visit them. Same interstate at the moment, which is a little bit of a different and unusual situation that we're in with the hard border closures we've got with West Australia, Northern Territory and Queensland particularly, just creating those real issues with getting exemptions and not being able to get exemptions for certain states, or where you've got your bubble communities, where you've got those border towns. So whole heap of new issues coming out of COVID, obviously, and that's across the board in most industries at the moment. So current or new applications that are being filed in the court considering a relocation of the children, whether it's interstate or international, will need to give some consideration to the impact of COVID-19 on those applications and alternate arrangements, and thinking about what those arrangements might be if people can't travel, if children can't travel, if children are, you know, being tested, if children are sick or parents are quarantining. So there's a whole bunch of different things that really need to be considered in that initial application. And ultimately, whether it is best for the children to relocate now when there is that uncertainty and when there's a bit of uncertainty around when they could see the other parent, or whether it should be delayed. I've also seen quite a few cases that had already gone through the court process and had been to their trial, where the judge was about to give a decision and then needed to write to the parties and ask them to make submissions about some of these issues that COVID have brought up, because they weren't contemplated at the time of the hearing, which could have been, you know, in 2019. So I'll just give a bit of background in terms of the general court process. I'm not sure how much you guys know, but once you file an application in court, it usually takes somewhere between 12 months to 2 years to actually get that heard by a judge, and that judge is then the person that makes the decision. That hearing could happen anywhere between a few months to a few years before the judge actually gives their written decision. So there is often evidence changes in that time. So one of the things that has been happening is that judges have been asking for parties to consider that COVID impact in that kind of intervening period before the judgment's been given, and then the judge has been able to include that as part of their consideration of the decision. So obviously it's incredibly relevant to that, maintaining a meaningful relationship between the child and the parent, because a relocation already creates some issues for that, but if it's going to be a significant period of time before parents can actually physically visit with the children, depending on the age, obviously, and the bond between the child and the parent, then that can have a much greater impact than the relocation may have had previously. So unfortunately, it's this this uncertainty that makes it very hard for us lawyers to give advice on these things, and it's that uncertainty that's creating, I guess, a lot of issues for parenting matters. So it's just the border closures, they're changing quite regularly, and they do vary state to state. So it really depends on which state you're in, which state the child's in, and whether you can get some of those exemptions, and then whether a parent is willing to quarantine if that's part of it as well. If a parent is able to relocate, so whether that's by consent or whether the court determines then that can happen, and the court says yes, they need to maintain a meaningful relationship with the child, usually what that would involve in your, again, I'll use the term pre-COVID relocation, that would usually involve, and again, as I said before, it really depends on how far apart the parents are living, but usually there would be extended holiday time, visits during the term, phone time, telephone time, time for family, special occasions and things like that, whether that's in where the child is living or somewhere else, and taking into account the flight times and things like that. But that physical time and that very regular travel, which is often required to make a relocation successful and required to make sure that the child maintains that relationship with the other parent. Where we can't have that really regular travel, it may even come down to the fact that travel at the moment is a lot more expensive because there's less flights, for example. So it can come across in different ways, but the effect is the same, that if the travel's not practical and the physical time can't happen, then that needs to be taken into account when the court's looking at these relocation matters. So I've just done a quick review of a few cases which are actually refer to COVID-19, because I just think it's interesting to see, I guess, how relocation matters were looked at previously, and then this has kind of really thrown a spanner in the works to a lot of them. So this is a recent case. I'll talk about 3 different cases, but they're all from 2020, so they're quite current and topical. So child was 2 when this decision was made. So this is one of those ones where they'd already had the trial, and then the judge needed to subsequently ask for a bit more information because COVID had hit. So child was 2 at the time of the trial, but the parties had been separated since the child was only very young. They were living in Melbourne at the time, and the mother had filed an application to relocate to Adelaide because she had financial support there. She could actually move in with, I think it was her sister. She had a lot more family support. Her sister had her own children. She had that emotional support from her. She could live rent-free. And she said that that was going to have a positive impact on her mental health, which then obviously means that she can be a better parent for the child, and it would have a positive impact on the child. Obviously, Victoria to South Australia. South Australia was one of the states that had quite a hard border closure, so that needed to be considered in the judgment, and the judge had asked for the parties to make submissions about what their proposal was. Essentially what happened, and this is something I think, in my view, this is a pretty reasonable decision for the judge to make, and I think this is something that will come across fairly often, is that the judge said, yes, the mother can go to Adelaide and move with the child, but she can only go after the January 2021 or when the border reopens with no quarantine requirements. So that means if the border between South Australia and Victoria is still shut in March, then she can't go until that border reopens. So the orders still did the, set out quite specific times for the child to spend with the father, but obviously because those times were impractical, if the border was closed, then the judge actually said, well, you need to kind of stay put until that border reopens. I think it would be interesting to see, and this is something that the court hasn't need to consider as yet, but it would be interesting to see if, for example, the South Australian border opened in January, and she goes in January, but then there's a further outbreak somewhere and the borders need to close in March 2021, and then the whole order falls apart. So that's not something that the courts needed to consider as yet. It'll be interesting to see if cases are brought to the court's attention under that kind of arrangement, because obviously then, you know, does she need to go back? She's settled the child in, then it becomes a different, I guess, best interest argument. So it'll be interesting to see if the court does need to consider something like that. Hopefully we don't need to look at that, because hopefully we will get it under control, but it's just something that the court's needing to look at, I guess, as it's progressing and needing to look at all the updated information. So this is another recent case. This one's a little bit different. So we spoke earlier about the two ways that these matters come to the court attention. So the first one was the mother had made the application before she moved. This one is where the mother had already moved and the father had filed for a recovery application. So the child was aged 5 at the time of the trial, but had been with mum and hadn't spent any time with dad until they were about 15 or 16 months old. So mum and the child, mum had actually moved to this town while she was pregnant. The child had lived there for the first 15 months of their life, and then she had moved to Sydney, and the child had developed a relationship with the father. The mother subsequently moved back to the town where she was from, which was about 670 kilometres away from Sydney, and dad was living in Sydney. So that was the relocation. Obviously a significant difference. And one of the other, I guess, practical perspectives that the court actually talked about in their judgment was the fact that the father couldn't fly directly from Sydney to this town where the mother had relocated. So even that might come into, you know, your relocation matters. If there's a short, direct, relatively cheap flight between the towns, that may have a very different impact in terms of the relocation and the practical side of things to if there's, you know, a flight and then a 2-hour drive to somewhere else. So it comes down to sometimes even as particular as that, because obviously that has a big impact on whether weekend time is possible or whether it's school holiday time. So the mother had moved in with her parents. She was unemployed, and she argued that she needed their financial and emotional support. And the court also, again, it was one where they'd already had the trial and then needed to give consideration to the travel practicalities during the pandemic and the fact that it had made it a lot more difficult for the father to travel. So ultimately the court did allow the child to remain living with the mother in the town that she had moved to, and ordered for significant and substantial time with the father. The court made, and this is, I guess, a bit of an interesting one in the context of litigation for parenting matters. So the court obviously needed to consider COVID-19 and the impact. So the court made a specific order that the parents use their best endeavours to communicate about issues arising from the pandemic, including travel restrictions. So the court was obviously putting the parents on notice that this is something that may not necessarily go away overnight and may not necessarily be resolved just through the fact that they've got this order or don't. So I guess encouraging the parents to communicate. Unfortunately, as lawyers, that can raise some concerns, because if these parties have gone all the way through to a trial and haven't been able to communicate necessarily particularly effectively previously, which is often the case if parties have lawyers and are involved in court proceedings, and these court proceedings could have been going on, you know, for 18 months or longer, it's a bit of it may have been a tall ask to ask them to communicate effectively about something that might pop up to change those orders. So it's one of those tricky ones that the court's encouraging people to do something that hopefully they will do, but it's just something, I guess, that may not necessarily come to pass. And the court also made an order that the father, at any time, if he is unable to spend time with the child due to COVID-19, that he can elect not to spend the time on a without prejudice basis. So that was just put in place, I guess, if there were travel restrictions or the father was concerned that he may be required to quarantine upon returning or when he got there, then he could notify the mother that he couldn't spend time with the child, but that was done on the basis that there wasn't to be an implication that he was doing that because he didn't want to see the child, I guess. So that was included there. I guess it's interesting though, because obviously that would preclude potentially him from seeing the child for a long period of time. So even in the context of COVID-19 and even in the context of that happening, the court still determined that the mother could relocate. And this is just the last one that I've looked at in terms of the relocations and the COVID matters. So the children here were 10 and 8. This one was an interim hearing as opposed to a final hearing. So the last two that I've spoken about, those were final decisions. So that was the court having gone through the court process, having gone through a trial, and the court deciding that that was what was to happen. This was an interim decision. So again, one where the mother had left with the children and the father had asked for them to be recovered back to where they were living previously. When you're looking at relocation matters and when you're looking at interim hearings in the court, an interim hearing doesn't provide the judge with a full opportunity to look at the evidence, and they can't make a decision about whose version they believe. So it's a really tricky hearing to be successful on, and often, and it's particularly tricky, I guess, the point of an interim hearing is to make a decision until the judge has that opportunity to look at everything more fully. If a parent is asking for children to be able to relocate on an interim basis, the judge would need to be very satisfied that that's not going to impact them if at a final hearing they decide they need to come back. So it's a big decision for a court to make. If a child and a parent are already living in a town, the children are attending a school and things like that, in my experience, the court's likely to maintain stability until they've got an opportunity to look at all of the evidence. So that's usually the way, not always the case. Obviously, there's always situations that come up, but just something to keep in mind. So this was an interim decision. The father was living in South Australia, as was the mother and the children. She relocated to New South Wales with the children, and the father had filed the recovery application. So the judge specifically referred to travel restrictions and then the fact that the father would have had to quarantine if he'd visited New South Wales and then come back to South Australia, and said that that was impractical, particularly, I guess, looking at it from an interim perspective, that it could have, that could only be until a trial. The judge gave weight to the fact that the mother's proposal did not enable the father to be involved with the children in a meaningful way. So I guess that's really coming back to that meaningful relationship perspective. I think the mother's proposal was essentially that, she would facilitate video phone time. But the judge said that having regard to the fact that there was an undefined period of time when the father may not be able to visit physically, then that wasn't practical and that wasn't in their best interest. So the children were ordered to return back to South Australia. So just, I guess, generally in terms of how the court has approached COVID-19 matters. So quite early on in the whole pandemic, the court issued a directive to parents, which is on the court website if you did want to have a look, but it's basically a bit of a statement that parents really need to be focusing on children at the moment, that they need to do everything they can to facilitate children seeing both parents and also to comply with orders that are in place. So really trying to focus people on the children and parenting arrangements and making sure those relationships are maintained, rather than using COVID-19 as a reason to not send children or not comply with those orders. So the court was quite quick to issue that statement, but as with anything, obviously there were still issues that needed to come to court for determination. So If orders were unable to be complied with and it was safe to do so, then the court encouraged parents to communicate and attempt to resolve issues. So some of the really, I guess, practical issues that came up from COVID, particularly in those early stages. So sometimes orders would say, mum picks up the kids after school on Friday and then drops them back to school on Monday. So there was a period where children were home being homeschooled and weren't at school. So the court was really encouraging people to try and get over those practical hurdles and focus more on how can we make sure the kids are going. So do we need to find a public location to do changeover and things like that. The court also implemented a COVID-19 urgent court list to deal with some of the more specific things that arose out of COVID. So, you know, some of the relocation stuff was relevant. So where people were living interstate or international, they may need to get different orders. Some of the practical things about where's changeover going to be, if there were health concerns in terms of spending time with children. So those issues that were quite specific to COVID-19, there was a separate court process set up to do that, and that was on a national basis. I guess that was helped by the fact that the court was doing more phone and video link up. So the matter would be listed, I think it was within 3 days, and then it could be before a judge within a week. So they really sped up those times that it took to deal with those really urgent issues. So as I was saying before, it's still quite early days in terms of the judgments that are filtering through that are referring to COVID-19 and any appeals. So those judgments I spoke about before, because they've only recently been decided, we don't know if they're going to be appealed. They may be overturned. We're just not sure. It's kind of that limbo we're in at the moment. And also taking into account, you know, whether, you know, if a relocation is granted and then there's another further lockdown, how that's going to impact. And I guess ultimately that kind of stuff may come up in that COVID list if it's extended, if it becomes a more ongoing issue. There was this quote in one of the judgments that I read, which is from a Canadian judge who was looking at, obviously, that we're dealing with similar issues the world over at the moment. So I just found this quote kind of interesting, and it really comes back to that, trying to focus people on that, on the children rather than focusing on the other external issues. So, but no matter how difficult the challenge, for the sake of the child, we have to find ways to maintain important parental relationships. And above all, we have to find ways to do it safely. None of us have ever experienced anything like this. We are all going to have to try a bit harder for the sake of our children. So I guess it's really, it's a really unprecedented thing we're dealing with in the family law context, but in all industries. So it's really that, you know, can we use this as an opportunity to make sure people are focusing on their children and doing the right thing, and hoping that we can have some of that communication happening. So that's the end of my presentation. I hope that was helpful and useful to you, and I hope that you were able to learn something today. If you do have any questions, the email address is up on the screen, so feel free to email through anything. You'll also get a feedback survey, so would love if you can have a look at that. In terms of other resources that we have a whole bunch of webinars from previous ones by me, but also other solicitors in the office. So feel free to go on the website and have a look at all the resources that we have, a bunch of webinars. There's information sheets that you can give to clients if you want to, and a whole bunch of articles and newsletters, and sign up for the newsletter and all those things. So we do produce a lot of material, so sign up for those things. If you do have clients that need family law advice, then we do offer no obligation fixed fee consultations, and the amount for those is on the screen. So just contact the office by either email or by phone, and refer anyone to us if you think they do need legal advice. Obviously, family law issues are so specific to each person, so we would recommend that people get legal advice before they do anything. I really hope you guys enjoyed that and found it useful, and have a great afternoon.